Hi friends, this is A.Brundarika. My topic is about exceptions to the rule, no consideration and no contract. As per the section 10 and section 25 of Indian Contract Act 1872, consideration is essential in the valid contract. No consideration, no contract. You can enforce a contract only if there is a consideration. While consideration are integral to contract, the Indian Contract Act 1872 has listed some exceptions whereby an agreement made without consideration will not valid. There are the six types of exceptions. First one, nature, love and affection. Second one, past voluntary services. Third one, promise to pay a time barred debt. Fourth one, creation of an agency. Fifth one, gifts. Sixth one, contribution to charity. Now briefly explaining about these six exceptions. First one, nature, love and affection. According to section 25 2 is valid if it satisfies the following condition. There are the three conditions to satisfy the love, nature and affection. First one, when it is in the written form. Second one, it should be registered under by law. Third one, it is between the parties standing in a near relation to each other. For example, X promises his friend Y to give 1000 rupees in writing and get it registered. For the nature, love and affection, when we write return form or under the registered, it must be a legal. It should be legal. Now the second point, past voluntary services. If a person has done a voluntary services in the past and beneficiary promises to pay at a later date, then the contract is binding provided. For example, Peter finds John's wallet on the road and returns to him. John is happy to find his lost wallet and promise to pay Peter rupees 2000. In this case, the no consideration, no contract rule does not apply. This contract is valid. The Johns did not promise to the Peter that he will give the 2000 rupees, but he was very happy, so he voluntarily take the decisions that to give the 2000 rupees to Peter. Like service was rendered voluntary in the past, it was rendered to the promiser. The promiser was in the existence when the voluntary services was done. The promiser showed his willingness to compensate the voluntary service. Now third exception, promise to pay a time barred debt. If a person makes a promise in writing signed by the authorized agent about paying the time barred debt, this is the valid despite there being the no consideration. The promise can be made to pay the debt in the part. For example, Peter owes 1 lakh rupees to John. He borrowed the money 5 years ago, but he signed a written promise to pay that 50,000 to John as a final settlement of the loan. In case there is no consideration, no contract rule does not apply either. This is a contract. For this, Peter gives 1 lakh rupees to John. He borrowed money 5 years ago. John borrowed money 5 years ago, but he signed a written promise to pay 50,000 John as a final settlement because Peter cannot give the 1 lakh rupees at a time to the John. So in this case, no consideration, no contract rule does not apply either. This is a contract. Now fourth one, creation of an agency. According to section 185 of Indian Contract Act 1872, no consideration is necessary to create an agency. Thus, when a person is appointed as an agent, his appointment is valid even if there is no consideration is paid. Fifth one, gifts. The rule of no consideration, no contract rule does not apply to gifts. Explanation 1 to section 25 of Indian Contract Act 1872 states that the rule of an agreement without consideration being void does not apply to the gifts made by a donor and accepted by the donee. Now, the sixth exception, contribution to charity. If a person undertakes a liability on the promise of another to contribute the charity, then the contract is valid. In this, there is no consideration and no contract rule does not apply. For example, earthquake and flood. These are the six exceptions for the no consideration and no contract. This is my project. Thank you.